Mr. Speaker, I declare my interest as a dispute resolution lawyer who sometimes advises on criminal matters. This bill makes important and wide-ranging changes in criminal procedure, which will enhance the administration of justice in a variety of ways. First, it provides greater transparency in the investigative and evidence-gathering process. Second, it provides better protection for victims of crimes. Third, it provides more incentives for whistleblowers to come forward. And fourth, it makes important improvements in the process before the courts. Now, I will touch on a few areas. The first is the protection for victims or complainants in sexual and child abuse offenses. Now, in the past few weeks, we've seen newspaper reports of serious sexual offenses being committed against young people, and even some shocking ones against older people. A common trend in many of these cases is that the victims are afraid of reporting the offense for a variety of reasons. These include the stigma of being a victim of sexual abuse, the fear of both the perpetrator, as well as the potential stress of going through the legal process, and potentially having to relive the process once again in court as the victim's evidence gets challenged in the adversarial process. Now, as court lawyers, we all know that as a defense lawyer, your job is to discredit the victim, so this creates a natural tension. Now, some of these fears the law cannot fully remove, but what we can do is to take what steps we can to reduce that fear. And a number of the important amendments in this act include the amendments to make the court process less intimidating for the victim, though hopefully not compromising the opportunity for the accused to challenge that evidence. Now, this includes allowing the victim to provide evidence by video, although I think the details on how the adversarial system will be preserved in this context are not yet available. There's also measures to prevent the victim, interesting measures actually, prevent the victim from seeing the accused in court, including the provision of a screen. But this does not necessarily mean that the accused will not be able to instruct his lawyer. So again, it's to protect the victim. And there's also procedures to hold parts of the hearing in camera, meaning out of the public eye, but not necessarily out of scrutiny of the adversarial process. So I think these are well thought through changes that will take away a lot of the stress the victim faces, while at the same time giving the accused the opportunities he would need to challenge the evidence as necessary, because as some of my other friends have mentioned earlier, it is important that the accused is innocent until proven guilty. But one must not underestimate the stress that victims face. And I think there is a much broader societal cause to this as well. One of the things that I think surprised many people, certainly myself, was the Me Too movement, which I think came to life after the allegations against Harvey Weinstein. And what was surprising was the number of prominent individuals who came forward to say they were victims of sexual abuse, but who had never themselves decided to make complaints prior to this or put themselves through the process. An even scarier case is that of Larry Nassar, the coach in the United States, who has been convicted of molesting young student gymnasts. So this is really scary, because this conduct that have gone unpunished and even unreported for years because victims were afraid to come forward. So I think it's important for us to make sure that victims are not afraid to come forward.